And the light they plan to shatter.
What do you say?
But when your love is gone,
How do you live?
seems like no hope for tomorrow.
He doesn't care.
Where you live or who you are.
See, my life is
You see, my life is broken. I don't know what to do.
change how they remain.
Yeah.
I will count on you.
When I can't see, I know. Whoa, and I cry out.
You feel.
Now I'm free. I know you can. I'm praying for healing. Where do you call?
When no one has the answer,
Where do you go?
the place you've known is no more.
When we'll be still.
All the tears, they just keep falling.
Doesn't care.
Pain doesn't care where you live or who you are.
Don't know what to do.
Change how they remain.
Count on you.
When I can't see. When I cry out. I know you feel. Now I'm praying. Praying for healing. Yes.
Ask you
We ask you to forgive.
The same love as we receive your love.
Take this time to hold on and wait.
just a little while.
Song of strength.
We're in the midnight. Come on. Just a little while.
Song of strength.
Sing so the same. Oh, everybody put your hand together and say it. Hold on. Say it. Say it. Just a little while. Say it. Oh, New York City, did you hear me? Say it. 'Cause we may endure for the night, but joy, Somebody say one time, say yeah. With your somebody say it again, say it.
Greetings, 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 greetings.
Did you know you could be entitled to a 5 or 6 figure?
Let's just get rid of this. And greetings to you all here at the Third Temple English Church of England. I am King Clifford Jefferson, descendant of Godfrey the fifth Caliban Jew, son of Folk, ruler of Jerusalem. I am the reincarnation of King Edgar the Peaceful, which we know as the King of Peace, or Christ, the Vicar or Christ, or the Good Shepherd, has many names, as we can see in back of me. It is September 5th, 2025, which is equivalent to the birth year 2975. I greet you in the name of King Edgar the Peaceful. I greet you in the name of my wife's Sister Galveston from the House of Galveston, as well as Archbishop Belmont from the House of Belmont. I greet you in the name of all officers and staff. I greet you in all the name of all those who are heirs, successors, those who pay their allegiance to the King in regards to that protection, as well as to those who are striving to get an understanding of what it is that we are here and called to do. Once again, I just want to thank you all for joining me today. It's been a busy time for me in court, dealing with the so-called preliminary deficiencies and difficulties in regards to how the court works. But nonetheless, the argument is still at its forefront and is being done as expediently as it can be done. Okay, so this is the reason why this lesson is being done today, which is called How the English People Became Black Wards of the United States. How the English people became black wards of the United States. You all would not want to miss this important lecture. You don't want to miss this important lecture. Let's see. Alright, let's get into it, right into the meat. A lot of it is going to go into what I talked about in part 1, part 2, part 3 in regards to the breach in legal continuity of the English government. And as a result of that breach, we had English people have no protection pertaining to the government that was established at the time of the proposal and the ratification of the 14th Amendment, Section 1, Section 2, Section 3, Section 4, and Section 5. Okay? As a result of that not being followed out, as we should see today, is a justification of how the English people became black wards of the states, i.e. the United States. And with that, we can start with this marvelous lecture. I asked AI first, so let's go to AI. Pay close attention to what's being said to the heirs today. If Chief Justice Thomas William Sumner Jr. is watching today's lesson, please pay close attention, because this is my argument. So it's not considered vexatious in the definition of what the word or the term vexatious mean, or the word vexatious litigant. Okay? The term vexatious litigant is a litigant who, based upon motions or complaints that's filed, is meant to harass or subdue the adversary, okay? Which is grounds for sanction and other measures that the court seem deemed reasonable in regards to the expectatious litigant which is in question. Okay? So in lieu of that definition, all right, we have to understand that it ain't the people who are considered vexatious in regards to them following the law. It is those who are offended by the law are the ones who bring claims or argue points based upon vexatious litigants. Very important to understand that. All right, we We'll talk about that in a second. I asked AI about the Tenure and Abolition Act. Was it incorporated in the New Jersey Revised Statute 46:2? There's a reason for why I asked this question. Let me blow it up for you, brothers and sisters, as well as Chief Justice Thomas Sumner Jr. can see. New Jersey Revised Statute raises the legal continuity of our English government, still present today in 2975, what you call 2025. I asked AI, did the Tenure Abolition Act of 1660 had anything to do with the New Jersey Revised Statute, or New Jersey statute indicated 46:3-2, governing property law? Okay? It said yes. The core principles of the Tenure Abolition Act of 1660 is incorporated, personified, ratified into the New Jersey Revised Statute 46:3-2. How the New Jersey statute reflects the 1660 Act? While not a direct codification, New Jersey statute indicated New Jersey Revised Statute 46:3-2 serves the same function as the English Tenure Abolition Act. It abolished feudal-style land tenures and replaced it with a modern system of ownership. Once again, it abolished a feudal system land tenure and replaced it with a modern system of ownership. Okay? So the New Jersey Revised Statute 46:3-2 and 46:3-1, the feudal ways of land tenure were abolished based upon the legislative enactment of a statute. Okay? Abolish feudal tenures. The statute especially addressed and abolishes former feudal tenures of honors, manors, lands, tenements, or hereditaments that were in effect before July 4th, 1776. We're not just going to deal with the abolition of feudal tenures from July 4th, 1760. We're going to go back as far as the Scottish interregnum of the demise of the King of England and all the other successors of the Kingdom of England. Because the only reason why there is no King of England is a result of the failure to demise, which is a result of what we call an interregnum. Okay? Okay, so as we can see, it abolished land tenures before July 4th, 1776, and establishes free and common soakage. It declares that these former tenures were converted into holdings of free and common soakage. This meant that land is held by paying rent or a nominal service, okay, which essentially equates to the modern concept of a fee simple estate, where ownership is absolute and not subject to feudal duties. Okay? Very important we understand this language. Links to earlier law. The statute referenced in the earlier New Jersey Act from 1795, which itself establishes the modern form of land tenure in the state. This shows a direct line of legal history from the old feudal system to New Jersey's current property law. Okay? So in summary, according to AI, now we only asking AI, okay? We know AI can become a problem if AI take control, okay? Guess what? AI has taken control because we call AI ancestral intelligence. And summary of New Jersey statute annotated for is going to do that's Joe, and its companion statute, New Jersey statute annotated for is going to do that's 1, carries on the legal continuity, custom, tradition established by the Tenure Abolition Act of 1660. It's showing that New Jersey's property system is now based on an ancient feudal obligation. Okay? Very important to understand what AI has to say about this and what I have to say about this, because it's uniform based upon what the legislative intent as created via the statute. Okay? So the statute cannot be considered vexatious other than it being to a person who don't want to follow the law. Let's look at what AI has said about that. Ask AI. The proverb, the law is vexatious to those who break the law. This is what it said. The proverb, the law is vexatious to those who break the law, means the legal system is frustrating, annoying, and burdensome for people who violate it, but not for those who abide by it. It is a philosophical statement about justice and human nature, implying that the law's complexity and restrictions are only seen as a nuisance by those who wish to act outside of the law. Okay? That's the definition of vexatious litigant. Those who are harmed by the intent of the law. Because we know that if you're in violation of the law will continue to harass you until you are subdued by the law. What law are we talking about? This law right here. This is why they want to lay me as a vexatious litigant. Because a vexatious litigant is a litigant who raises claims that can actually harm or subdue an adversary. We know when we look up the word adversary means enemy. So yes, in that sense, in regards to the enemy, is my obligation, like it is the court's obligation, subdue, if we cannot subdue, harass them until changes can be made in regards to the violation of the law. Okay? Very, very important for you to understand that. Let's go here. Okay. Okay. So as we can see, brothers and sisters, the title of this lecture 1 second. So we see the title of this lecture is How the English People Became Black Wards of the United States. So let's actually find out what a ward is, okay? All right, and what the ward is subject to, all right, in regards to some type of protection as a result of you being called a ward. Okay, so let's watch a video on that real quick.
Office, your ultimate guide to local government services and public records. Let's get started.
What is a ward of the court? Have you ever wondered what happens when a child or an incapacitated adult needs legal protection? This is where the concept of a ward of the court comes into play. A ward of the court is someone, usually a minor or an incapacitated adult, who is placed under the protection of a court or a government entity. This can happen for several reasons, such as if the child's parents are unable to provide proper care, or if the child is at risk of abuse or neglect. In the United States, for example, if a child violates a law, such as committing a felony, the court may decide to take responsibility for the child's treatment and control. This means the court can limit the parent's control over the child, and even order the child to be taken away from the parents if it seemed necessary for the child's welfare. The court's role is similar to that of a parent, known as in loco parentis, where the court assumes all legal authority to make medical and legal decisions on behalf of the child. This includes supporting the child, ensuring they receive the necessary education and maintenance. In some cases, children in foster care also become wards of the state. Here, department responsible for foster care takes on the role of the legal guardian, ensuring the child's well-being and making important decisions for them. The term ward of the court can also apply to incapacitated adults who need legal protection. The court may appoint a guardian to manage the adult's affairs and make decisions on their behalf.
Stop. So an incapacitated adult can also be considered a ward of the court. Those who are not able to make competent decisions on their own. All right? And that does not have to do with you being old age, suffering from Alzheimer's or what they call dementia. We're talking about people in their 30s, 40s, 50s, and 60s. If you are incompetent, what I'm talking about is you are in fact a ward of the court. Because every time you go on there, what they ask you need an attorney to represent you. It's either that or you go pro se. If you go pro se, you're really screwed because pro se means you must know the law. Okay? The majority of you don't know the law. Let's get it.
In countries like Canada, the term permanent ward or crown ward is used, particularly for Indigenous peoples who remain under the guardianship of the Crown due to specific legislation.
You hear that?
The process of becoming a ward of the court is
1 second. It says in Canada, the terms like permanent ward or crown ward are used for Indigenous individuals under guardianship. The process to declare someone a ward is reserved for exceptional situations to protect welfare. In the UK, the High Court can serve as a child's supreme legal guardian for safety. The concept ensures legal protection when personal guardians fail to meet care requirements. Very important to understand that there's different wards governing different wardship practices in regards to different jurisdictions that deal with wardships, okay? This one deals with crown wards who are permanent wards, okay? Very important that you keep that in mind. Continue.
Typically used in exceptional circumstances to safeguard and protect the individual's welfare. For instance, in the UK, the High Court can be appointed as a child's supreme legal guardian to ensure their safety and protection. So to sum it up, a ward of the court is someone who is under the legal protection of a court or government entity. ensuring their safety, well-being, and proper care when their own guardians are unable to do so.
When their own guardians are unable to do so. Okay?
To
Our
learn
own
more,
guardians.
check out
One
these
second.
links.
Just close this out. So warrant of the court is one that's subject to the laws of the court as a result of legislation passed in regards to the concept what we call Providence Patriarch, father of the nation. Okay? Father of the nation. Okay? If you're a crown ward, a permanent ward, then you must be protected by that father of the nation versus some other ward of the state that's protected by who's assumed to be Providence Patriarch. And that other person will be what we call the Attorney General. Okay? Let's get it, brothers and sisters. Let's look at it. Alright, so we see, let's look at the 10-Year Abolition Act. Since that had to do with New Jersey Revised Statute 46.3-2 and 46.3-1. Okay? It says it must be in free and common soakage. Okay? Free and common soakage. Now look at the scope, alright, of the 10-Year Abolition Act concerning wards in possession of the courts. Okay? Because 10-Year Abolition Act is incorporated under New Jersey Revised Statute 46.3-1 and 46.3-2, and AI said it. Okay? I'm going to prove that not just those statutes, but other statutes in New Jersey as well. 46.3-5, 46.3-15, all regard to the law governing wards of the court in possession of the courts who are minors, incapacitated, subject to what we call inquisition post-mortem because they're not at the age of accountability. Okay? Let's see. The 10-Year Abolition Act of 1660 passed by a de facto king. Nonetheless, he was sitting on the King of England, so the legal continuity of the government of England can continue. Sometimes known as the Statutes of 10 Years, is an act of the Parliament of England, not Scotland, not Ireland, but of England, which changed the nature of several types of federal land tenures in England. The long title of the act was an act taking away the courts of wars and lotteries and tenures in capitite and by night services and purveyances, and for the selling of the revenue upon His Majesty in lieu thereof. So the main key point in regards to the topic of today's lesson is courts of wards, who are the courts put in place to watch over us as a result of no Providence Patriarch to protect them. Okay? Very important. So let's look at it directly based upon the definition of courts of wars and lotteries. Let's see that. Before we do that, let's examine a little bit more. Yeah, let's examine a little bit more. It is passed by the Convention Parliament in 1660, shortly after the English Restoration of Charles II. The act replaced various types of military and religious services that attendants owned to the crown with soakage. Hear that? Soakage. Okay? This was called in the days of King James the Great Contract. Yes, the one who's mentioned in your Bible. It was called the Great Contract. All right? Very important for us to understand that. This was legislation, all right, that goes back to the Courts of Wars Act of 1540, 1541. The laws were amended by the continuous laws of Act of 1749, the Statute of Law Revision of 1863, the Statute of Law Revision of 1888, the Administration of the States of Act of 1925, which we're going to talk about that, and every other enactment thereafter. Okay? Very important that we understand that. Alright? provisions. Section 3 of the Act repealed the Courts of Wars Act by Henry VIII from the House of Lancasters, okay? The one who overthrew the English government as a result of the conflict that was sprung in the houses of our ancestors who are members of the government, i.e. English Puritans. And as a result of that, we have what we call the 100-Year War, the War of the Roses, the Black Plague, the Sicilian War, and every war that dwindled down from there. Okay? Very important for us to understand that. Alright? Okay. So we see that the Tenure Abolition Act, which is the same act that we see in the New Jersey Revised Statute in regards to freeing common soakers. Please do not lose that train of thought. Okay? Because now we go to the Courts of Wars and Library based upon the Tenure Abolition Act and the Convention of Parliament in 1660. Let's look at the convention first. Okay? So let's go look at the convention first, where this what we call de facto legislation was implemented. Nonetheless, it was a legislation. Okay? The Convention of Parliament of 1660. I hope you're watching, Chief Justice Thomas William Sumner Jr. Because I'm older than you, brother. The Convention of Parliament of England from 1660 to from April 25th, 1660. That's a key date. All right, because the order in regards to what Chief Justice Sumner is reviewing was given in the Chancery Court was given on April 25th, 2025. Let's show you. I just love God's humility on me. I might as well do it. Right here. Let's see. Let me share. April 25th. Right here, brothers and sisters. Our ancestors are in the mix. Okay? Chief Justice Thomas William Sumner Jr., who is an English subject by way of him being descendants of slaves as a result of the emancipation through the 13th Amendment and the citizenship via the 14th Amendment. Then you as a judge should understand very well what it is that I'm saying in regards to the declaring me to be a vexatious litigant, which in fact I am, if it means subduing the adversary. Okay? April 25th, as we can see here, the order was given in the Chancery Court, which is being appealed as of today. One of the respondents and defendants in the case wanted the court to declare me a vexatious litigant. It's right there. Okay? Why would they want the court to declare me a vexatious litigant? Let's look at the word vexatious litigant, first of all. This is what the appellate court should be doing. Alright? A vexatious litigation is a legal action which is brought solely to harass or subdue an adversary. So if you're an adversary, then if you subdue the adversary based upon the law, then that means that you had to do that job, because contrary to you doing that job, their adversary was constantly violating the law. Okay? Very important for us to understand that if we're going to declare someone based upon the definition of a vexatious litigant. If anybody is vexatious litigant, it's the defendants, not the plaintiff in this matter. Because my argument is the law. And the law is vexatious to those who break the law. Okay? Very important that we clear that up real quick. Alright? So back to the Convention of Parliament. The Convention of Parliament concerning the Tenure Abolition Act of 1660 followed the lone Parliament that has finally voted for its own dissolution on the 16th of March that year. So they voted for their own divestment, their own dissolve, their own doomsday. Okay, right here, elected as free Parliament. It says the lone party that had finally voted for its own dissolution on the 16th of March that year, elected as a free Parliament, i.e. with no oath of allegiance to the Commonwealth or to the monarchy. It was predominantly royalist in its membership. It is assembled for the first time on April 25th, 1660. Okay, let's read it. After the declaration, no, I don't want to read that. Let's go a little bit further down, right here. The Convention Parliament was dissolved by Charles II on the 29th December 1660. The succeeding Parliament was elected in May 1661 and was called the Cavalier Parliament. It set about both systematically dismantling or recasting all legislation and institutions which has been introduced during the interregnum and confirming of the acts of the Convention Parliament. So that meant that everything that was done under the government, under the office of that interregnum, which means that there is no king in place. They recognized that there were no king because that's what the interregnum means. Let's look at it. Interregnum. And interregnum was the period between execution of Charles I on the 30th of January 1649 and the arrival of his son Charles II of London on the 29th of May 1660, which marked the start of a restoration. During the interregnum, England was under various forms of republican government, meaning that it was a commonwealth or republic form of government, which that means there was no king, which you have now. Okay? So right now, is still an interregnum as a result of the overthrow of the legal continuity of the English government based upon the English people, and the English king was once considered wards of the state. But we are not wards of the state because the wards courts of library was abolished, okay, in 1660, and therefore those wards that was in the possession of the courts of the state fell in the protection of the crown as crown wards. Okay, very important for you to understand that, because we're going to go right into that definition right now. Let's do it. Courts, wards, and libraries. Still talking about the Statutes of Tenure Act of 1660, which involved courts, wards, and libraries. Means wards that were in possession and under protection of the courts. Okay, which we said that the Tenure Abolition Act was incorporated in New Jersey Revised Statute 4623-1 and 4623-2. Okay, so if that's the case, that means that based upon the title of the selection, the English people have now became wards of the United States because now they identify with themselves as black people versus English people. Let's read it and weep. The courts of the wards and libraries was a court established during the reign of Henry VIII in England. Its purpose was to administer a system of feudal duties, but as well as the revenue collection, the courts were also responsible for warships and library issues. Okay? Warships and library issue. What is warship? Let's look at it. Warship. In order to understand worship, you must go to war law. War law. In law, a war is a minor or incapacitated adult placed under the protection of a legal guardian or government entity such as a court, such as a person may be referred to as a ward of the court. Very important that you understand that. The wardship jurisdiction is an ancient jurisdiction derived from the British Crown's duty as province patriae over the English people who were wards of the Crown when at the time when the House of Stuarts dissolved the prerogatives of the Crown as a result of the interregnum through the Convention of 1660 under the Tenure Abolition Act of 1660, which still has us under protection, but now under the right protection. Okay? So I want you to understand war law and warships through lobby of season that were abolished by Henry VIII through the Tenure do what we call the Tenure Abolition Act. And there was a lot of abolition act in regards to warships based upon everybody trying to claim to be the father of the nation when there in fact was not. What is Parens Patriarch, first of all? First stop. In law, Parens Patriarch is a public policy power of the state to intervene against an abusive or negligent parent, legal guardian, or informal caretaker, and to act as the parent of any child, individual, or animal who is in need of protection. For example, some children, incapacitated individuals, and disabled individuals lack parents who are unable and willing to render adequate care, thus requiring state intervention. Okay? State intervention. Let's see. Parens Patriarch relates to a notion initially invoked by the King's Bench in the 16th century in the cases of non-corpus mentis, means dead in the eyes of law. Well, I don't mean dead in the eyes of law, but it has something to do with that. Okay, unsound mind. Okay, and if you unsound mind in the law, then you are clearly of unsound mind. Okay, very important we understand that. What else to say about Parens Patriarch before I move forward? There's quite a few cases on that as well. Okay, I can move forward. Okay, so Parens Patriarch denotes to those who are subject to the status as wardship status. Okay, that are subject to the status as wardship status. This is very important, especially when looking at indigenous people. Okay. It says indigenous people in Canada remain wards of the Crown as a result of the Indian Act legislation. Some scholars and political organizations such as the Assembly of First Nations have argued that this represents an apartheid-like system of government. Okay? You have it in France and the United States. Okay? Very important that we understand that. Alright? Why? Why is this important? Let's go back to courts of wars and rivalry. Let's go back to courts of wars and rivalry. Right here. Right here. History. Warships are minor heirs. You hear that? Now they associate those minors with heirs. So you are an heir, just a minor, incompetent. You're an heir, but incompetent. It says worship of the minor heirs of a tenant-in-chief was one of the king's ancient feudal incidents among estates, marriage, relief, custody, or even of idiots, etc. That is to say, a right of royal prerogative dating back to the feudal principles of seigneurial guardianship. King Henry VIII of England prevented his tenants from depriving him of royal revenue sponsored in the 1535 laws called what? The Statutes of Uses. Okay? The Statutes of Uses, which we're going to see right here in New Jersey Revised Statute. First is going to do -9. This statute is right here in New Jersey Revised Statute. Before we go there, let's read a little bit more. Identification of warships. Check it out. On the death of every tenant-in-chief, the escheator of the country, all right, in which he held land, was required to hold an inquisition post-mortem. We know that means to escheat. Same thing. But it must be done by lobby of season and reported to what? To who? The Court of Chancery. This is what's going on now. Why? Because it's a part of the doomsday, the last judgment, or the day of judgment, which identifies the size and location of all holdings that rents and services due under the feudal land tenure, which was goes back to the Doomsday Book, as I just said. The name and age of the deceased and the name of the age of his heir. A copy was sent to the Exchequer in 1540, the Court of Wars and Libraries. So what is Inquisition post-mortem? Let's look at that real quick, those who don't know it. Listen, y'all better listen. Inquisition post-mortem, formerly known as escheat, Inquisition after death. This is why Inquisition of office is called, or founding of office, or traverse of office needs to be understood. It said Inquisition post-mortem, and formerly known as escheat, meaning Inquisition after death. Who gets it after you die? It's an English medieval or early modern record of the death, estate, and heir of one of the king's tenant-in-chief, made for royal physical purposes. The process of making such inquisition was effected by the royal escheators in each county where the deceased held land. You hear that? Where the deceased held land. The earliest escheat was made in 1236 in the reign of King Henry III, the son of Henry II, the son of Henry son of John, son of Henry III, son of John, son of Henry II, son of Godfrey, the 5th Count of Anjou, son of Folk, ruler of Jerusalem. Okay? And the practice ceased in 1640 at the start of the English Civil War. Did you hear that, brothers and sisters? English Civil War was a result of the Glorious Revolution, was a result of who inherited the throne of England. Okay? Very important. Okay? It's called the War of the Three Kingdoms. England, Ireland, and Scotland. So it says that the earliest escheat was made in 1236 in the reign of King Henry III. King Henry III was of the Plantagenet crown, which we, the members of the 13th Church of England, are descendants from Godfrey, the 5th Count of Anjou, son of Folk, ruler of Jerusalem. So these are our heirs. These are our ancestors, okay? That we have a right to inherit it as a result of us being incompetent or not being in the right state of mind based upon our understanding of warship status, which we came up under the authority of crown wars based upon the intentions of the Teen Abolition Act of 1660, as well as the convention which was the Teen Abolition Act was enacted. Okay? Very important. We're going to go right back to that in a second. Purpose. These treaties were ordered by a writ from the King's Chancery to investigate of death of tenants-in-chief in order to assess what monetary value was due to the king from his so-called feudal incidents, comprising, for example, feudal relief, warships, and marriages. This is called defining of office. Such revenue which resulted from the death of his tenant-in-chief from significant proportions of the medieval royal revenue. Okay? Very important. All this goes all the way back to what we call the Magna Carta. Okay? That being said, we come here to the Abolition Act. Let's go right back here. Because as it said, it was incorporated where? In New Jersey. Did it say that? Let me go back to it. Where's it at? Right here. Okay. If this law was incorporated in New Jersey, as we just said, let's just read it while they read. If this is what the law says, how can I be a vexatious litigant? Chief Justice Thomas Warner Jr. How can I be a vexatious litigant? It says, yes, the core principle of the Continued Abolition Act of 1660 is incorporated in New Jersey by statute 46:3-2, where it says, King of England, body of policies, corporate or other persons. Okay? So if this is in fact the case, let's go back here. Let's go back to the Continued Abolition Act. Okay. Statute Act. We already know what that was called. The Great Contract, going back to King James. That promise. Okay? That promise. All this was based upon the administration of the states, of the wards, who were called crown wards. Okay? Concerning the administration of the estates, because it's right here, Administration of the State of 1925. Let's look at that Administration Act of 1925. But we're going to see they didn't want to go past back prior to 1540. Because they know if they did, then everything they did prior to that will be revoked. Okay? They didn't want to do any law that goes before 1540 because anything that happened after 1540 was a result of us not being there. Okay? But based upon the Administration Act of England in 1925, I think we passed by King George, not King George. Matter of fact, let's go to it. All right. Administration Act of 1925. Let's look at it. When you're dealing with the administration of estates, they become what? Your trustees. All right. Very important. And if it's incorporated in New Jersey, on the forces going to do that too, then they must incorporate on the forces going to do that 60:1-28. Rights in charge of Great Britain, safe from bill, and act to incorporate trustees with the society for property held in corporation placed thereof. Okay? So the Administration Act goes all the way back to the acts that predate the Administration Act of 1925. Let's look at them. This is the act right here. What predated these acts? Who we have here? Edward the First. Edward the First. Edward the First. Edward the First. Statute of Westminster. Okay? The indulgence conditional bus. The laws governing entails of estates. That's why when you go to New Jersey by statute, forces going to do that 15. You'll find it right there in the legislative intent. What's next? Another one concerning the indulgence conditional bus. What else? Another one concerning the indulgence conditional bus. The law governing entail. Which one is this one? Right here. Let's do this one. All right. Let's go right here. Before we can get to Henry VIII, we're going to go back to Edward III concerning the administration of estates of heirs who were left estates by way of them being the beneficiaries of the trust that was left intact as a result of what Martin versus Waddell said by the king. okay, as trustee. So what is the Administration Act of 1347? Let's look at it. If it's here. It's not there. We're going to go back. For the sake of time, I'm not going to look for it. What else? Alright, so the main laws we want to deal with based upon the administration of the states prior to 1925, we have to go back to the Statute of Westminster. And that's concerned they don't condition the bus. Let's start real quick. Because we know crown land is intel land, and the king personifies the crown. It's inseparable from it. Okay? Statute of Westminster, like the Statute of Westminster 1275, is a code in itself, contains the famous clause, "De donuts conditionalibus." What does "de donuts conditionalibus" mean? Let's look at it. The Donuts Conditionalibus, or Estates Tale Act of 1285, is chapter of the English Statute of Westminster. It originated the law of entail forbidding the landholder to sell his land except to his heirs. You hear that? To his heirs. This is Edward the First, brothers and sisters. Not Edward the Second, his descendant. Not Edward the Third, his descendant. But Edward the First. Okay? Very important. That brings us here. Right here in 2024, the Donuts Conditionalibus is alive and well. It's alive and well. Judge Thomas Jr. So how can I be a fictitious litigant when the law says that I'm not a fictitious litigant? All right. Only person that can be harmed by a fictitious litigant is those who don't follow the law. Okay? So yes, in the definition of fictitious litigant, I mean to bring harm or subdue or harass what we call an adversary. It's my obligation. Alright? Why is my obligation? Look what y'all did. Look what you did. The state of New Jersey. Estates entail, their Donuts Conditionalibus are abolished. How the hell that happened? Whenever any conveyance, will, or instrument in writing should have to be made, wherein the grantee, not the grantor, because the grantor said it should be abolished, but New Jersey abolished. Why? As a result of what is that they do. Okay? They claim to have the power of escheatment when they actually don't. Whenever the conveyance, will, or instrument in writing should have to be made whereby any grantee, devisor, or other persons become livery, succeeds in law or in equity of such estate in real estate, as the statute under 13th of Edward the First called the statute of entail. Why did they mention this king by name? What happened held estates in fee tail or any other type of character, such conveyance, will, or instrument now should be vested in what? Fee simple to such grantee, meaning that they changed it as a result of the tenant-in-chief carving out new tenants for himself and in charge of the feudal tax on it, which they call free and common soakers for their purported reasons. Okay? Very important to understand that. But as we can see, we have a right to to bring these claims in regards to why they don't want to entertain these claims as a result of their being offended of why the statute is going to cause harassment or even subdue them as a result of revealing that they are in fact the adversaries to the law. Okay? Very, very, very important. Alright, why? Estates were not supposed to be abolished because of Queen Pentoris, which we also have in the same statute. In 2025. So how can that be a fictitious living? The Georgia Vice statute, right here. Elliot shall freehold Queen Pentoris terranum. From after March 18, 1795, any freeholder may give or sell or alienate the real estate whereof he is or at any time should be seized if he simple or any part thereof at his pleasure, and such donor, purchaser, or alienee shall hold the same free or anything of services to the donor, seller, or aliener. So there you see it right here in the Georgia Vice statute of the continuous legal continuity of our authority, under authority of the crown, being used by the de facto king to benefit them, okay? Which is totally in violation of the legal continuity that was there prior to the breach, okay? Very important for you to understand that, all right? Let's continue. Let's show you the breach. Let's go back to Courts of Wars and Library to understand this a little bit better. Courts of Wars and Library. Alright, so we understand that warship status of heirs that are incompetent, automatically it goes to the guardianship of what we call the state, or the government, or the court, or the legal guardian, whoever has some type of overseership over you, okay? So we're dealing with Courts of Wars of Library, which we know according to New Jersey Vice statute, which the Courts of Wars and Library was incorporated, which abolished Courts of Wars and Library, meaning that the only person that was supposed to be overseeing the wars was the crown, okay? And the only way that was done is by way of what we call the statute of uses, okay? But the reason why it's not being done, because no one understands the statute of uses. They keep thinking it's some foreign law over in some foreign country practiced by foreign people, okay? When it's not. Let's see. Warship of the English heirs, who are now called black wards of the state of the United States, is a result of the United States, who was the tenant-in-chief under the king's authority. That would be the King of England, all right, prior to the federal king coming over and setting up shop. That will be the House of Tudors, that will be the House of Stuarts, that would be the Proprietors, that would be the colony, and that would be your present states in question. Okay, so we are still warships, nonetheless we are still heirs, just incompetent of the tenant-in-chief who put us into position. Okay. And that is to say that the royal prerogative dating back to the federal principle of seigneurial guardianship set up by King Henry VIII of England prevented his tenants from depriving his royal revenue by sponsoring what? The 1535 law called the Statute of Uses. How many of you know what that law is? Let's see. Okay? The Statute of Uses. The Statute of Uses, or the law governing use, and we know use deals with the law of usury, and usury means the use of property that does not belong to you. Because possession of property and ownership of property are two questions that are right now before the court. The Statute of Uses was an act of the Parliament of England enacted in 1536 that restricted or prohibited or divested the application of uses. And what is uses? Let's define it. What is use law? Use is a term in the property law of common law countries, amounts to the recognition of a duty of a person to whom property has been conveyed for certain purposes to carry out those purposes and contests used and equivalent to the benefit given, i.e. you are a trustee. Uses were equitable or beneficial interest in land. In early law, a property owner could not dispose of his estates by will, means by alienating voluntary, nor could a religious house acquire it. When we say religious houses, that we meaning a religious house 501c3s, those that were in contrary to the government set up by the religious institutions, which were non-profit institutions, i.e. non-for-profit and for-profit. Once again, non-for-profit, non-profit are totally different because non-profit and for-profit are actually one and the same. Okay, non-profit and non-profit and for-profit are those who are simply there to make money, whether they make it on their own or their money is being granted to them. All right, this is the business of legal entities that are not a part of the government. They are called non-profits. Non-profits are non-governmental legal entities versus a legal entity, which is the non-profit. Okay? I mean non-for-profit. Non-for-profit is a legal entity that is there for the public utility, the public good. Okay? Very important to understand that versus what we call a non-profit. Okay, non-profit is a non-governmental entity that's there to make money. They only serve the general good. Okay, very important to understand the difference. We know non-for-profit fits the description of a religious house, okay, or a charitable institution, okay, which falls under charity. Charity goes back to grace. So it's a usual, equitable, beneficial interest in land. In early law, property owner could not dispose of his estate by will, nor could religious houses acquire it, other than the original house. What religious house are they talking about? Just to be specific. Okay, for us to get into that is a whole other argument. It says, as method of avoiding certain common law rules, the practice rules are making fealment to the use of or upon trust for the persons other than those to whom the possession, seizing, or legal possession was delivered, to which the equitable jurisdiction of the Chancellor gave effect, i.e. the King's Constitution. The Statute of Uses was passed in 1536, and an attempt to remedy the abuses which were occasioned by this invasion of the law. However, the statutes failed to accomplish its purposes. Okay, let's see. Now you get into what we call cestui. All right, those type of terms. All right, we call it the statute of mortmain, which means dead pledge. Okay, that's what we call it. That was passed by Edward I, same guy we're talking about. So we're talking about use law governed by the Statute of Uses, which was passed by who? Henry VIII in 1535. Now it's mighty strange that this statute right here, called the Statute of Uses, which in regards to the Teen Abolition Act, okay, of 1660, which will incorporate New Jersey revised statute for that's 5. It's very important to understand where I'm going with next. Going next, okay? Where I'm going next. Let's see. How can I make this connection? just want to miss nothing. Okay, let's make the connection. The statutes of uses. This is your statutes of uses in modern day. This is your statute of uses in modern day, passed by Henry VIII in 1535. They ain't gonna put it in the statute, but this is damn well what they're talking about. Okay? This is damn well what they're talking about. Conveyances of uses, governing use law, 2024. Only person left out is King Henry VIII. Everything else still remains intact. Why? Because of the interregnum. The Treaty Abolition Act passed in 1660, and the Convention of Parliament in 1660 was passed in doing a interregnum, a Republican form of government, or a Commonwealth, which we call a revolutionary government, which resulted in a revolutionary breach and a legal continuity of that prior government that was there prior to the breach. It says here, every person to whom uses or uses any real estate, and it say real estate, it says real estate. It did say real estate. When we say real estate, we're talking about land first, before we're talking about property that sits on the land, because those are known as fixtures. Every person to whom the use or uses of any real estate within the state have been sold, given, limited, granted, released, or conveyed, means transferred by deed, granted any legal conveyances whatsoever, or that shall have to be granted by a deed or conveyance whatsoever, and his heirs or assignees shall be held to be in full and ample possession of such real estate to all intent, construction purposes, as of such person, his heirs and assignees were possessed thereof by solemn of livery of season, and any possession, usage, custom, and contrary to that form of conveyance is not withstanding, brothers and sisters. It's right there. The statutes of uses are governed by livery of season. Livery of season is based upon inquisition post mortem. Let's go through that before. No, matter of fact, I'm gonna close out. Let's see. Tomorrow I'll do part 4, not part 5, the breach of the legal continuity of the government, and I'm going all the way back to what we call the Union prior to the divesting of the Union when it became the Union and Confederate Unions. Okay, we go back to that argument, but it didn't. All concerning those wards, English wards, are right now subject to the laws of the courts, which are not English courts. Okay? Livery of season is an archaic legal conveyancing ceremony formerly practiced in Feudal England and other countries following the English common law, used to convey holdings and property from the grantor to the grantee. Let's get a visual look at that, because a lot of you probably lost. Let's look at that visually. Judge Thomas, Chief Justice Thomas, this is what I'm talking about. When we say grantor, we're not talking about seller or lender. When we say grantee, we're not talking about purchaser or buyer. We're talking about grantor and heir, or grantor and grantee. And we're talking about matters of conveyance through livery of season. If livery of season cannot be conveyed, this is called inquisition post mortem, which results in what we call interstate. Okay? You don't believe that? Let's get another example of that to make it concrete. There's no way I can be considered a fictitious litigant. Just Thomas Jr., especially being getting your degree, a doctorate degree from Rutgers. Power of interstate is a result of us not being there. That means including you, Judge Thompson of Sumner Jr., because you're not there doing your part. Okay? None of us there are doing our part. Whether we're citizens, whether they're acting some official capacity, whether we're police officers, whether we're teachers, whether we're judges, no one's dealing with the involuntary alienation of what was guaranteed by the 14th Amendment under Section 1. Life, liberty, and property, and due process of law. Okay? As a result of you being there, all this was zero before they came upon the scene. The only reason why they got it is because you want to be yourself, and automatically it falls under interstate, it automatically falls under the power of escheatment, and when things is street, that goes to either the owner or those who claim to be the owner through acquisition of sovereignty under what we call the laws of discovery. In that case will be the state of New Jersey. And then they fall upon the eminent domain power, taking private property for public use without just compensation to the actual owner, because the person who's going to be the owner is the seller or the lender. Okay? Now, as a result of the seller and the lender putting us, changing it from grantees to what we call buyers or purchasers, we became wards of the state. Okay? So as a ward of the state, you have no protection at all, and now they're allowed to adverse possession, which is an open encroachment, hostile and total takeover of something that actually belongs to you. Okay? I aim to stop with that without your help or with your help. Okay? Very important to understand that. Why is this important? Let's go back. Library seasons are occasionally legal form under the common law of England, where it says the only form of common law under library seasons provided that a valid conveyance of fealty. You hear that? A valid conveyance of fealty, meaning if the land is under feudal law, the only way that the land cannot come under feudal law is to go by the requirements as set forth by the library seasons. The only form of common law provided that a valid conveyance of a feudal tenure in land require physical transfer by the transferor, not the seller, not the lender, okay, but the grantor, the one who's able to transfer the property. A purchaser or lender cannot transfer the property without the owner's or the grantor's consent. That would be subjugation. The oldest form of common law provided valid conveyance through tenure of land requiring physical transfer by the transfer of the transferee. That means the grantor or grantee, without the witnesses, without the purchaser, without the lender, without the title insurance company going out there, without the broker, all right, being there. It says that the grantor and the grantee or the transfer and the transferee in the presence of a witness, that means your people, in lieu of the conveyance of a piece of the ground itself. It is the literal sense of a hand-to-hand passing of a mound of soil, or a twig, or a key to a building or land or other token. Okay? There's only two varieties of which how can be done. Library of law and library of season. In the deed, whereby a party met together and go on the land, is how you do it now. While you going with the broker or the mortgage company, and they themselves make the conveyance, which I might add is unlawful. Why? Because they know that you're not the owner, because they make you get title insurance with defective title, which they know is defective because that's what they learn in school as a curriculum for title insurance. And being a person to sell title insurance, you must be licensed by the state. So the other form is library of law, whereby the parties went within sight of the land and the transfer declared that the possession was being given following the recipient entering onto the land. So it meant that when our ancestors promised us, excuse my French, this shit, they didn't have to be there when they gave it to us. All right. The only thing that we did is remember the process of library of law, which is called operation of law, because the alien cannot inherit land by operation of law. Okay. They only purchase it from a seller. Okay. And it can be divested of it and by way of inquest of office in regards to how they acquired the property outside of library of law, be a library of deed. Let's go to the statute to qualify that. We just read the statute. Okay? And if you're not kin to who? Ashton, the king of the Anglo-Saxons. If you're not an heir of the Anglo-Saxon kings, then you don't have a right to any property whatsoever. Let's read it. And we're just in most mortem. It's treatment. Once again, Under the feudal system, all land belongs to the monarch and was therefore either held by him directly under the royal indemnity or domain, or on behalf directly or indirectly. Those who held the land directly on the king's behalf were known as tenant-in-chief. So if you got some interest in land and that you're in possession of, you better make sure that you can prove that it came by way of a sovereign grant based upon how corporate powers are derived, because if not, then you're in violation of the charter, which was not granted to you based upon live season. It was done by way of what we call adverse possession. As there was an heir, the king kept the land until unlawful season took place. The heir paid some money once that heir come of age. What age would that be? 21. I.e., at 21, you cannot be considered a ward of the state unless you are incompetent when you become 21. Okay? Very important to understand how important it is that these lessons are not just these lessons, but I as your king. Not because I'm saying it, but as a result of what case law says. And I'll close that on this. Martin versus Waddell. If the king held such land as a trustee for the common benefit of all his subjects and inalienable as a private property, I am unaware to discover on what grounds the state of New Jersey can hold the land, is then discharged of such trust, and can assume to dispose of it to a private and exclusive use of an individual. 61-28, rights in the charge of Great Britain, saved from repeal. An act to incorporate trustees of religious society. That will be us. Alright? For property held in corporations placed thereof. That will be the state of New Jersey. Okay? So if they held the property bond of vacatia as a result of the power of the king to his feet is not there as a result of the king not finding his office, then guess what? There are the trustees. It said it. If the king held his land as trustee for the common benefit of his subject and inalienable as private property means it cannot be subjugated. I am under no discover of what grounds the state of New Jersey can hold the land discharge, which means to alienate of such trust, and can assume and dispose of it to private and exclusive use of an individual. If it was a trust estate and the king for the benefit of his subject, upon the revolution, the government of New Jersey became trustee in place of the king. Hear that? And the trust devolved upon such government, and the land became as inalienable in the government of New Jersey as in what? The hands of the king. And the state must be bound to hold all such land subject to that trust, which as contended and embraces a common right of fishery and the watery and dredging for all oceans and land covered by the waters. And if this be so, there certainly can be no power of the state or any state of the United States without a breach of that trust, breach of legal continuity of the constitution of government that was there prior to the breach, which is by way of suppression that was done on March 15, 1776, as declared by each union that declared independence as a result of the issue involving the 14th Amendment that had to do with the citizenship of the emancipated slave under the 13th Amendment that must be construed to the English common law of England and Latin common law English history. Okay? So if that is the case, then we must look to the law. The law is not fictitious. The legislators who made that law is not fictitious. Well, the judge who interpret that law consider fictitious. If I'm doing the job they're doing, then how in the hell can the judge total consider me to be fictitious? And within that, you are obligated, based upon 14th Amendment, Section 1, to protect our life, liberty, and property that you took through the 5th Amendment, which is called the Taking Clause, and restore our government. If we don't want to be it, then we choose our own, based upon Section 2 and Section 3 and Section 4, and there's nothing you can do about it. Why? Because let's get to proof. Let's get to the proof in closing. Concerning the 14th Amendment. Senate Resolution number 16 passed 24th of January 2002. So that meant that. Matter of fact, let me just show you this. How long the 14th Amendment has been dormant. Okay? A lot of you don't even know that. Let's see how long this 14th Amendment has been dormant. From 1868 till 2002, the 14th Amendment has not been applicable on the state level in New Jersey. Let's look at it. Chief Justice Thomas William Sumner Jr., if you're watching this, everything depends upon you. Summoner or Sumner means summoner. Okay? Let me just show you that real quick. What you are obligated to do. Order the show cause. Core warrant to. Alright? Sumners. Family crest and coats of arms. This case, you look at it in the eyes of your ancestor, Sumners, and this is the reason why you got the surname. Then I declare that you act according. Sumner's history, family crest, coats of arms. Only way you find it, it's English. In Medio to Seminole Ibis. So our ancestors are controlling all his brothers and sisters. Etymology of Sumner. The Anglo-Saxons of Britain first developed the name Sumners. It was a name given to someone who was a summoner, a petty officer who sided and warned people to appear in court. The surname Sumner is derived from the Anglo-Saxon French word summoner or summoner, which in turn was derived from the Old French word summoner or summoner, which means summoner. Okay? Found in Oxfordshire. Okay? Going all the way back to the Doomsday, William Hastings at the Battle of Hastings, okay? Which resulted from the Norman Conquest. Very important, Chief Justice William Sumner Jr. Alright? This is what you should be teaching your descendants. I reviewed the ceremony that you had in regard to you be appointed based upon your tenure in, I think it was, what they mentioned, Philadelphia. There was a identity had, and you gave a speech in regards to those who made a meaning or impact in your life, such as family. Okay, so if that is the case, then you must look past your immediate family and go to the family that your immediate family is rooted in. Okay, very important. So with that, let's go back into the legislative intent before I close out. Chief Justice Sumner Jr., I would love for you to leave a comment if you're watching this lesson. You can be incognito, but I don't mind. I ain't trying to blow your spot up on the chat line or on YouTube, but I will be doing it in that courtroom. Okay, let's close out on this. Right here. Like, share, subscribe. Leave a comment once this lecture is over. For all those who are watching it. State of New Jersey's legislator, November 16th. This is the legislator, the lady that holds everything up that that holds the body up. So the legislator holds the government, i.e. the body of politics, up. Okay? If the lays give out, then the body's going to fall. What they say, a house divided amongst himself cannot fall. Here you have a house divided amongst himself until those who were divided in the house were kicked out. This is the bill that kicked those who were divided in the house, going all the way back to why the 14th Amendment was created, and those who didn't want to implement the 14th Amendment, resulting in the emancipation of the English people. All right? Let's read it. One second. Okay, in closing. It's an auspice. Revoke Joint Resolution number 4 of 1868, which sought to withdraw New Jersey ratification. I missed something. Let me go back here. Let's look at on the website of New Jersey how corrupt New Jersey actually is. Concerning the 14th Amendment, which made free slaves citizens. Text of the 14th Amendment to the United States Constitution. Assembly Joint Resolution 1, ratifying the 14th Amendment. So they ratified based upon the proposal. All right, the proposal was in 1866. It wasn't ratified till 1868. Okay? Assembly Joint Resolution ratifying the 14th Amendment. Senate Joint Resolution number 1, withdrawing the consent to propose the 14th Amendment. Message of Governor Marcus Lawrence Ward. It's that word Ward. You've been talking about wards of the state, right? Senate Joint Resolution. All right? Message to the governor. So Governor Marcus L. Ward sent a letter to the president in regards to the joint resolution presented by the legislations who were divided in regards to the ratifying, let alone the proposal of the 14th Amendment for the benefit of the free slaves. Nobody else, inclusively and exclusively free slaves. And I'm letting you know, you wasn't black, you were English, okay? Then the Senate and the House override not just a letter from Governor Marcus L. Ward, but also the joint resolution, also the legislative ratifying of the 14th Amendment. It was overwritten as a result of the joint resolution provided by the legislation intent of the legislative tenures or holders of those officers. So let's see here. Senate overrides Governor Marcus L. Ward's veto. House Assembly overrides Governor Marcus L. veto. Then Senate Joint Resolution overturns or revokes everything that was done prior to Joint Resolution 16. Okay? Let's read it in brief. Joint Resolution 1 of the State of New Jersey back in 1866 to 1868. All right? proposal ratifying. Joint resolution ratifying the amendment of the Constitution of the United States be resolved by the Senate General Assembly of the State of New Jersey that the amendment of the Constitution of the United States proposed at page 1, the first section of the 39th Congress by resolution of the Senate and House of Representatives of the United States of America in Congress assembled to the several states legislature be in the same and hereby ratified upon the part of the legislature and made a part of the Constitution. That is the United States Constitution of the United States. Now look what New Jersey did. Senate Joint Resolution number 1 went to withdraw consent to the proposed 14th Amendment, let alone the ratifying of it. Alright? Joint Resolution withdrawing the consent of the state to the proposed amendment to the Constitution of the United States entitled Article 14 and rescinding the joint resolution approved September 11th Annos Dominicus 1866, whereby it was resolved that the said proposed amendment was ratified by page 1, the legislature of the state of the state of New Jersey, having seriously and deliberately considered the present situation of the United States, to declare and make known that the basis of all government is in the consent of the government to what? Resolve their assent to the proposal and the ratification of the 14th Amendment, because as they said in the actual context of the joint resolution, it will be a dissolving of their self-government. Okay? They said it. I'm not going to go through it. You can read it on your own. Then Messenger Marcus Lawrence Ward sends a letter to the president about vetoing that joint resolution of 1868. To the Honorable Senate of the State of New Jersey. Mr. President, I hereby leave respectfully to return without my approval Senate Joint Resolution number 1 entitled A Joint Resolution Withdrawing the Consent of the State to Propose Amendment to the Constitution of the United States entitled Article 14 and rescinding the Joint Resolution approved September 11 Annos Dominicus 1866, whereby it was resolved that the said proposed amendment was ratified by the legislature of the state, meaning that Marcus Lawrence Ward ratified the 14th Amendment based upon the proposal and the ratifying of it, but shortly after it was overturned by the Senate and the House of Representatives. We see it right here. Senate overrides Governor Marcus' veto, and the Senate House overrides Governor Marcus' veto. So from March 15th, 1868, March 24th, 1868, the Senate and the House of Representatives has vetoed the implementation of the 14th Amendment in the state of New Jersey, outside of what the United States said when it was proposed and ratified in 1868. Okay? And this is what Governor Greevey had to say about that to put the stamp on the matter. So let's look at it in closing. In closing, March 13, 2003, LBO Sirius, Speaker of the House. Richard J. Goody, President of the House. 1. A joint resolution revoking Joint Resolution number 14 of 1868, which sought to withdraw New Jersey's ratification of the 14th Amendment of the United States Constitution. Whereas the 14th Amendment to the United States Constitution granted citizenship to and protected civil liberties of free slaves. They didn't call you black, they didn't call you African, they didn't call you anything in that book. So you better think seriously about what you identify in regards to this 14th Amendment, because if you read United States v. 1 Kim Art, they can sue that case to the common law of England and out of the history of where the origin of the common law originated from, and that goes all the way back to Alfred the Great. So it says the 14th Amendment of the United States Constitution granted citizenship and protection to civil liberties of free slaves, and whereas the 14th Amendment also prohibited the state from abridging the privileges and immunities and citizens of any citizen, depriving any person of life, liberty, or property without due process of the law, or denying any person equal protection of the law. And whereas the rights guaranteed by the 14th Amendment are part of the foundation of a free society. Stop. If the foundation of the 14th Amendment is based upon the foundation of a free society, then what was the foundation of society prior to the creation of the 14th Amendment? Was it in fact a free society? No, because it was free for those who were practicing slavery, because the slave, it was not a free society. The only way he can go to a free society was to run. Okay? So there was a free society prior to the American Civil War. Okay? Prior to the American Civil War, it was only based upon the unified states that were heavy in slavery. It only resulted when they passed the 13th and 14th Amendment that you had a conflict with the Union states that resulted in the American Civil War, as a result of them now having them free their states, which created a free society, okay, for only the exclusive and inclusive free people. Nobody else was included in this package deal. And whereas in 1866, New Jersey legislature acted to ensure these rights be ratified by the 14th Amendment, and whereas thereafter New Jersey legislature in 1868 attempted to withdraw its ratification of this amendment by passing the Joint Resolution Number 4, and whereas both the Federal Secretary of State and Congress refused to recognize New Jersey's attempt to withdraw ratification of the 14th Amendment, it became part of the United States Constitution on July 20th, 1868. And whereas the attempt to withdraw New Jersey ratification of the 14th Amendment is contrary to the state-long tradition and respect for and protection of the civil rights of not just the free person, but all person. And whereas even though the attempt to withdraw New Jersey's ratification of the 14th Amendment was without effect, there is nevertheless a need to rectify this misguided action. Now, therefore, be it resolved by the Senate and General Assembly of the House of Representatives, parts out. Come on. Bear with me. Where's it at? Okay, right. This is the actual brief. Be it resolved by the Senate and General Assembly of the State of New Jersey, Joint Resolution Number 4 of 1868, which attempted to withdraw New Jersey ratification of the 14th Amendment, is hereby revoked. Duly authenticated copies of the Joint Resolution shall be transmitted to the Federal Secretary of State, presiding officers of the Congress of the United States, and each member of New Jersey congressional delegation. The Joint Resolution shall take effect immediately. So if this is in fact the case, then Chief Justice William Thomas Jr., you all will follow the instruction of the law, which are not considered vexatious to those who are in line with the law. Within that mind state, I should be allowed to file my motion for an appeal interlocutory. Okay? Very important for us to understand that. And with that, I'll close out. Thank you all for being here today, as well as all you scholars or wannabe scholars, as well as those who are trying to somewhat curb what it is that I'm doing. Once again, as they said in Jones versus Freeman, it says that one of the greatest gifts to the king was the law. And let's go to it in closing. Now, in fact, now I'm going to quote it. But one of the greatest gifts to the king is a law, and one of the and that's an inheritance to the king is a law. And without the law, there will be no heritage, and thus there will be no king. Okay. So with that, I'm going to greet you as I always greeted you. And that's in what? Peace and love. Peace.